This conference will now be recorded.
Okay, the live stream has started.
Thank you. Good morning, everyone. Welcome to Policy Committee, September 9th, 2020. We're going to start with the first item on the agenda, which is a minutes review. The minutes were circulated. Is there a motion to approve?
I've reviewed the minutes and like to move forward with their approval.
And thank you, Dr. Bechtel, and Dr. Giacalone is seconding. All in favor say aye.
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 Any opposed? Hearing none, that carries, and those are approved. We'll now move on to rule review update, and I'll turn it over to Kim.
All right, so you have our spreadsheet and our rules schedule. We have a number of rules that are coming to the full board today for adoption. These are the PA rules and the respiratory care rules where there were not any comments. Last month, we also had some rules where there were changes, and so those will be coming to you for adoption in the October meeting. We still have a number of rules at CSI, and we are going to have a public hearing on our one respiratory care rule where we had an error last time. So that we'll have a public hearing on September 24th, and then hopefully we'll be able to proceed with that. So that's kind of where we are at this point. Does anyone have any questions?
Yeah, can you advise us or remind us on the one error for the public hearing on September 24th?
Sure. There were a number of respiratory care rules that were filed, and when 4761-9-04 was filed, it was a rule that was amended, but more than 50% was amended. So you need to take that through as a kind of a rescission of the old rule, and then you have the new rule. So it's kind of two things together. And when that got filed with JCAR, we didn't have both steps of that process on that particular rule. And it was noticed at the public hearing, so it was withdrawn. When you withdraw at that stage, you have to start all over again, unfortunately. So that's what we're doing. So I don't anticipate that there will be any issue with it, but just procedurally, we had that error that we have to correct.
Any other comments or questions? Okay, hearing none. Kim, do we need to move these to the full board, the PA and respiratory care rules that had no comment?
They're already on the schedule for the full board, so I don't think there's anything that needs to happen at the policy committee for those today.
Okay, great. And if that concludes your report, we can move on to the legislative update.
Okay, it does. Thanks.
Thank you.
Good morning, and thank you for the opportunity to provide the legislative update. If it's okay with you, Dr. Soin, I'll go into the next item on the agenda and talk about the legislative tracker at the end. So I'll just now go through the legislation that we are especially concerned with or has seen activity since we last met. Last week was very busy in terms of legislative activity, and in your board materials, you have a copy of both the legislative summary and the tracker. So I'm following along directly down the summary if you want to follow along. They are in numerical order, so there's no, they're not listed by priority or anything. First is Senate Bill 246. This is the occupational licensing reciprocity bill. At the last meeting, I had advised that the Legislative Affairs team had been meeting with the bill sponsors to request changes to allow the board to the ability to vet out-of-state applicants to the same standard as in-state applicants. I'm happy to report that we have been notified that many of our requests were granted and will be included in a substitute bill, which is expected to be accepted at the next bill hearing. And while we are extremely grateful to the sponsors for their willingness to work with us on these issues of retaining our current standards, there are some issues that we are still concerned with. The 5-year look back period is problematic and the fiscal impact is less than ideal. So the 5-year look back, it was originally 2 years in the bill. So they did give a slight extension there as far as, how long we're able to look back into the background of these applicants. But we will continue to advocate for an unlimited look back, which is what we had requested in our amendments. House Bill 203 impacts mobile dental services, and it passed out of the legislature last week and is currently awaiting signature by the governor. The final bill was amended to include language.
Can I interrupt you real quick? I think Ms. Montgomery has a question on 240.
Oh, sure.
Oh, I think she might be having sound troubles though.
Okay.
We can't hear you. Okay, we'll come back to your question on 246 when we get your sound fixed.
So House Bill 203, like I said, impacts mobile dental services, passed out of the legislature last week and is awaiting signature by the governor. The final bill was actually amended to include the language from Senate Bill 303, which is around pharmacy consult agreements. The amendment to include the pharmacy consult agreement was put in at the end of the committee and went straight to the floor for a vote. The amendments authorize a pharmacist to enter into a consult agreement with certain advanced practice nurses and physician assistants for the management of patient drug therapies. Additionally, it allows pharmacists to order and evaluate laboratory and diagnostic tests for patients rather than limiting it to blood and urine tests as under current law. House Bill 263 is another occupational licensing bill that we are monitoring very closely. This language would require that the board provide a comprehensive list of criminal offenses that would prevent a person from becoming licensed in Ohio. The problem with that is that the board may only consider those listed offenses when making a determination on an applicant who has had a prior criminal conviction. Additionally, the board is only granted the ability to look back for 5 years for the background check. When the bill was in the Senate, we worked with a consortium of state healthcare boards to present a package of amendments to make the bill a little more palatable for the state healthcare boards and commissions. Unfortunately, very few of the amendments were accepted when it was still in the House committee. So the medical board, along with the other Ohio healthcare boards, will continue to work together to attempt to improve upon the language and then we would like to retain the ability to, vet applicants at the same standard that we are currently vetting them. House Bill, sure.
There's a couple of questions on this one. I think Mr. Giacalone had a question first.
Real
Sure.
quick, why is the sponsor so helpful on this criminal absolution?
I think right now, for whatever reason, the legislature is, interested in giving second chances. And unfortunately, the one size fits all approach is not, the best for every single board, but that's the best way that they, see to solve a problem. So we're working through it the best that we can. And, I think that with this one, especially, we working with the other boards and commissions, have the potential to, get some things in there and some things out of the bill to make it a little more easy to digest and make it a little more workable for us.
So are we working on this criminal list then? Because that could be a laundry list, but so be it.
Yeah. Best case scenario, we don't want to, paint ourselves into a corner with these things, I think. And that's the biggest issue with this. And, that's the biggest issue for all the boards. So I don't think that we've started a list yet. No. And I think that, as the bill progresses through the legislature, that's something that we definitely need to be concerned with if we think that this is going to pass.
Okay, thanks.
I've got a question. Can you hear me?
Yes. Ms. Montgomery.
I'm sorry. My internet is giving me a problem. Turned off. I agree with you. Making a list means that if you've listed it by legal interpretation, whatever you haven't listed, we can't. There's a very little wiggle room if we want to reject something. So I think we have to avoid the list if we can. Forgive me if this question has been asked. have we asked to be able to list at least violent and sexual offenders, just as House Bill 263 has, to be able to look back and look at all the criminal behavior without a limitation of time, to ensure that we can deny based on a sexual offense or a violent offense? Are we considering that amendment or using some variant of House Bill 263 to amend the Senate bill, the Senate bill
246?
246?
So that's certainly a possibility, and it's definitely on the table for the options that we have available. I think that first we would like to present our case to the sponsors and to the stakeholders in this, that we don't want to paint ourselves into a corner. We would like to not list specific offenses, but if we can't get that, that's definitely a concession that we could consider, just to have the unlimited look back on the violent and sexual offenses.
Yeah, no, I'm not saying it's either or. I'm saying, in addition, you try to amend so that you have you can take a look. You do a look back on all of your licensees for your record check, and then the look back gives you, if there's a violent or sexual offender, violent sex or violence offense, you can deny a license. And not suggestion that's limiting it. It's really expanding your ability to, that they may have a 5-year look back and not a limitation, but it's an exception to that 5-year limitation. I'm not trying to limit. You understand what I'm saying?
Yeah, sure. And I think it's been discussed internally, and like I said, that's certainly an option. If all we get is a 5-year look back, we can ask for, I think that the sponsors may be receptive to at least discussions about whether or not we can expand an unlimited look back for certain offenses. But I think the strategy for now is just to push for a complete unlimited look back for medical professionals.
Mm-hmm.
Does that answer your question?
Yeah, it still doesn't address the moral turpitude and the good character question. I assume you have to massage that language that they're objecting to, and you'll work on it. So.
Dr. Johnson?
Yes. Is Representative Kohler aware that most of the boards that we get our board certification requirements from require good moral character and moral turpitude? Are they aware of that?
I'll be honest, I don't know. And listening to Representative Kohler's testimony, that he has addressed that, it's certainly something that I could, bring to him as to sort of bolster our argument that we, would like to see some changes to this language.
Well, in one aspect, they're requiring board certification, but then in another aspect, they're saying, we don't have to worry about good moral character. So they need to be aware of that, because you can't have one without the other.
Right.
Of course, the counter to that would be, well, then why do we have to do it? Because you're already doing it under the board certification process. I mean, we got to be careful when we throw that one out.
Not all licensees are board certified.
True. But aren't the majority or not?
I don't know the percentage.
Most hospitals are requiring it if they have any hospital privileges. I think they're giving like 6 to 8 years to get it. And most insurance companies are requiring it as well.
So ironically, the people that aren't getting the board certifications are probably the ones that this should apply to the most.
a complete agreement.
That's a really good point, Sharon.
Sorry, go ahead.
That's a very good point, Doctor.
Were there any other questions on 263? Oh, Mr. Ganadakis?
Yeah, thank you. Just some general context, and I share all the concerns that everyone, my colleagues on the board have. In the legislature, there's a groundswell of support for regulatory reform, for deregulations. Many members of the leadership of the Senate have been to the White House to meet with Vice President Pence on this issue as well. So it's an issue that is near and dear to the legislature's heart. And I think what we need to do is highlight the aspects of who we regulate as a regulatory board versus some of the other professions in the state that may deserve to be streamlined to help those with criminal sentencing reform and what have you. But we need to thread the needle and explain the impact of changing our standards versus changing the barber standards, which are completely night and day different. If you can get me in there, right there. So look forward to working with Jill and the team and trying to thread that needle with the legislature.
Thank you. Okay, so then I'll move on to House Bill 341.
Before you move on, I had
Sure.
quick, if I may, Dr. Soin. I didn't get to ask my question on House Bill 203, and I hate to go backwards, but I just had a quick question. So, in this bill, pharmacists can enter into consult agreements with nurse practitioners and PAs without oversight of physicians. Is that what I'm understanding?
That is not my understanding. The physician relationship is still there. It doesn't take that away. It just expands it slightly. And I think that maybe our legal folks might be able to answer that a little more clearly than I can if they're on here.
Dr. Feibel, the language talks about the PA must, be under a valid supervision agreement, and the nurse practitioner must be authorized by the collaborating physician. So they do have, that language, which is a current requirement anyway.
I just wonder if the physician would even know this consult agreement was going on if they weren't part. I mean, there should be some. Anyhow, it's probably too late, but there should be some place for the physician that the physician assistant or nurse practitioner has to tell their collaborating or supervising physician that they're entering into this agreement.
Right. So we will need to do rules. So our rules for physicians are almost done. I think you'll see those for final file in October. We'll need to do rules for PAs. The nursing board will need to do rules for nurses. And they will need to consult with us and the pharmacy board on those rules. And we need to consult with the pharmacy board. The language says PAs authorized by their supervising physician. And it says for the nurses, the nurse practitioners, authorized by their collaborating physician.
Okay, thank you.
And we do have rulemaking authority.
Hi. If you'd be so kind, I had a quick question also about 203, where there's reference to diagnostic tests. What diagnostic tests are we talking about? Do we know?
I will have to get back to you on that. I can delve a little deeper into that.
Shouldn't be able to order an MRI based on this, or that does give them broad-based authority to order tests, and I do not like that at all. That's them practicing medicine at this point.
That was the thought that went through my mind too when I saw diagnostic tests. I thought, are they going to be able to order MRIs?
I think Dr. Bechtel has a question, and then I have a question for Chelsea. Go ahead, Dr. Bechtel.
Yes, I share that concern also. I think that when you order diagnostic tests, results come back, and how do you handle those results? Is the pharmacist going to take action on those results without any physician involvement? It just makes me concerned that things could fall through the cracks. There would be adequate physician follow-up. So I think we really need to be really cautious about what diagnostic tests can be ordered and how those results are handled and what the follow-up will be.
Yeah, so building on that is my question. So let's say one of my patients sees a pharmacist and they order a diagnostic test that had an abnormality that could lead to a bad outcome. Ultimately, am I responsible for that if I didn't order the test? That would be a question I'd like answered.
And that's another question that I'll have to, do a little bit of research and get back to you.
Just a question, is the diagnostic test in conjunction with the PA and the NPA? I mean, I don't think this is just a standalone. They were diagnostic tests. I thought this was in conjunction with the physician's assistants or the nurse practitioner's therapy or consult agreement. So wouldn't it be limited by whatever they would designate would be appropriate? I don't know what a pharmacist would do with an MRI, quite honestly, or a CT scan or anything else. Practically, it doesn't make any sense. But yeah, I would hope there'd be some kind of brackets around what the tests are and what in conjunction with those two authorized practitioners to order the test. But I may be wrong.
Sure, and go ahead, Kim. I'm sorry.
Oh, I was just going to say, I think you're right that it's limited by the consult agreement.
I still think there should be broader guardrails around this, that they should not be ordering MRIs, CTs. I mean, there's no reason for a pharmacist to ever order those tests. And based on this, as long as the consulting PA says it's okay that they're able to do that, I don't know what a consult agreement means. They have to run everything past the PA or MP before they do it, or can they just order indiscriminately? I just think this is a really dangerous, both for cost of medicine issues and inappropriate training to be able to order these particular tests.
Yeah, so on this note, I think we hear everyone's concerns and the themes are similar. And I would suggest that perhaps Chelsea gets the answers to those questions and gets back to us, and then we'll respond appropriately. But I think that all of the concerns are noted and appropriate. So we'll make sure we protect the public on that note. And so Chelsea, we'll assign that to you to get more information and pass it along to us, please.
Great, thank you. So I'll move on to House Bill 341. This passed out of the legislature last week and authorizes a pharmacist to administer any long-acting extended release drug prescribed to treat drug addiction. An amendment was added to authorize certain advanced practice registered nurses and physician's assistants to develop protocols to permit individuals and employees of service entities to personally furnish or administer naloxone. The bill has been delivered to the governor for signature. House Bill 492 would expand the ability of physician assistants to perform procedural sedation for the purpose of rapid intubation. The language would also update the term physician supervising agreement to collaborative agreement, which the PAs believe better represents the relationship between the physician and the PA. There are some concerns around this bill, around the scope of practice, and we are currently meeting with board members and stakeholders to address those concerns. House Bill 606 passed out of the legislature last week also. This bill provides civil immunity for healthcare and emergency services provided during government-declared disaster or emergencies, and for exposure to or transmission or contraction of certain coronaviruses. The final bill included language to extend the protections through September 2021 and has been delivered to the governor and is awaiting signature. House Bill 679, which is our telehealth bill, is something we're still working on. Our legal team has drafted amendments addressing the concerns around initial visits, consistency and standard of care, medical board rulemaking authority, and synchronous technology based on the discussions of the ad hoc committee and in the discussion in this last committee meeting. Those amendments are scheduled for review at the next ad hoc hearing this afternoon. And finally, I need to inform you of House Bill 673. This bill would authorize pharmacists to administer COVID-19 vaccines and order COVID-19 diagnostic tests. The bill is not in the tracker, and it's not included in the information that you have, but it will be included in the live tracker. So you'll be able to see that once you have access. Speaking of the tracker, the spreadsheet that you have is the PDF version of our new legislative tracker, and upon approval of the committee of this layout, all board members will have access to a OneDrive version, which will allow you to view any changes or updates to legislation in real time. We'll provide a PDF each month of the spreadsheet, but you'll be able to access the OneDrive document at your convenience. Sierra has been so kind to put together an instruction sheet to access the link, and she'll be sending out the links along with those instructions. So thank you, Sierra. That concludes the legislative update, and I'm happy to take any other questions.
I know, Betty, you have a question, so we'll start with yours.
And I'm sorry, my internet went out, so this question may have been asked before, but I think that as we go through what I love, Chelsea, you and the team have done a great job on the tracker, and this is such a more robust approach for us as a policy committee. Well done, Jill. Did a great job.
Thank you.
I'm sure, Dr. Soin, if we have, and this is tricky, but we need to talk a little bit, relying upon our people with boots on the ground, what our stand is, whether we're going to be interested parties or whether we're going to oppose or whether we're going to support. Because on some of these bills, you'll see that our current status based on former behavior is that we're acting as an interested party. And in some of these cases, now you have to be careful. You don't want to be Dr. No for everything, and you don't want to, and you want to work with your partners and all that. But some of these, I think we have to change our status into support or from interested to oppose or support. And I think we need to talk about that policy firstly internally and then work through the committee. And I know this is an art. It's not that you can write a policy on it generally, but I think Dr. Soin is chair. I think we all as policy members need to know, where are we legislatively? Where do we stand on this bill? Yes, no, maybe,
Yeah, I'd be happy to comment on that, and perhaps if Chelsea has an opinion as well. First of all, kudos to Chelsea and the team, Stephanie, and everyone involved in this legislative update. Probably the best one that we've seen in a very long time. And on that note, 2 to 3 months ago when we met in policy committee and this was first brought up, I told everyone, rest assured, we're going to make some significant progress. And I'd like to say that I felt like we did that this month with this tracker and all that. And part of it is rolling things out in phases and putting this architecture together was kind of a heavy lift to get everything in. And now that it's in there, starting next month, we can be a lot more robust in our opinions. And I think this first month, as we were putting together the legislative tracker, we just had to get the architecture and all of the bills and everything sort of in there. But I agree with you. We'll start being more robust on, a recommended position to the board, where we could even list an unofficial recommended opinion and then have board members weigh in on policy committee if they differ. But that's something I'll work with Chelsea offline and we can get going for the next.
Thank you, Dr. Soin.
Yes, Mr. Giacalone.
Chelsea, again, great job on the tracker. Just one question, and maybe it's there, and is there a hot link to the actual bill in your tracker?
There is not currently, but that is something that I thought about, and I guess it just didn't get in this version. But that's something we can definitely add.
Yeah, can you? That would be helpful because
Sure.
Again, summary is great, but if you ever want to see the bill, it's helpful as opposed to having to go through the website to grab.
Great idea, and that'll be easy to implement. Chelsea, I have a question. House Bill 492. Rapid intubation to for the PAs, pink slipping patients, providing procedural sedation, and changing from supervisor to collaborative. These are pretty robust changes in extremely vulnerable patients. Rapid intubation, someone on the brink of death. Pink slipping, someone you're taking away their constitutional rights. Providing sedation, even for a minor procedure, patients can die. I have extreme concerns about that, and I want to make those noted. And I'm pretty sure the other board members would agree, knowing the board members for quite some time, but I wanted to make that comment. And Dr. Schottenstein and Dr. Coccarella have some comments there.
I completely agree with that. And, I think it's ironic that in the same breath, they're proposing to decouple national accreditation from licensure. In other words, to decrease the degree of, essentially accountability for one's competency while simultaneously substantially expanding scope. It just doesn't feel like a well thought through bill. And really, I think back to the conversation about taking positions for and against, this would be a bill that I would take a position against. It concerns me.
Yeah, this is Dr. Coccarella. I just wanted to echo really what both of you said. The way this is written, or at least the way I understand what I'm hearing or reading, I wouldn't support this. The airways are difficult, and we tell residents and students and even fellow attendings, it's the only procedure that has nearly 100% chance of death if you don't successfully complete it. So, and these are patients and families that are completely relying on the expertise of the operator doing it. And if it goes poorly, you will have a catastrophic outcome, if not death, probably permanent disability.
And I certainly hear, all of the concerns. We are aware that, this is a disturbing piece of legislation. We are working with the lobbyist who represents the PAs, and, having discussions with, some board members as well. So it's definitely, something we're actively working to, limit, I guess, is the strategy at this point.
Thank you. So if there are no other comments, great job, Chelsea. And we'll move on to the Board of Pharmacy rule on vaccinations.
Thank you.
Thank you. We have recently received several communications from the pharmacy board regarding immunizations. So I'm going to go through several things, but chief among these is the proposed rule change. You have a memo in your that details pharmacy board proposed rule 4729:1-3-02. And per the authorizing statute, the pharmacy board must consult with the medical board prior to adopting rules related to physician established protocols to be followed by pharmacists and pharmacy interns engaging in the administration of immunizations, as well as rules specifying immunizations. In the memo, I have laid out the relevant differences between the new rule and the current rule, or the proposed rule and the current rule. The proposed rule is a combination of 3 existing pharmacy board rules. Chief among these to bring your attention to is number 7 on the list, which is allows a pharmacist to do any immunization approved by the United States Food and Drug Administration for the prevention of COVID in accordance with the limitations set forth in the statute, 4729.41. In relation to this, and to provide us some context about this, yesterday I received an email from the pharmacy board, and they sent us a communication from the State Board of Emergency Medical, Fire, and Transportation Services, which states basically that on August 19th, the board passed a motion that the board recognized that EMS certificate holders are permitted to administer vaccinations so long as the route of administration is within the scope of practice and the certificate holder administers the vaccination pursuant to medical direction and training on the specified vaccination, which includes adherence to recommendations and instructions of the FDA. in this communication, the medical director states that this motion will allow EMS providers to administer a COVID vaccination if one is developed. So that's given to us to provide us context to what another board is doing in relation to this COVID-19 vaccination issue. Lastly, as additional information around the vaccination issue, and then I'll circle back to take any questions on the proposed rules, but by way of information, the pharmacy board in August also sent us a guidance document that it had formulated that basically is explaining that HHS, the Federal Department of Health and Human Services, has expanded access to childhood vaccinations. This document was providing FAQs to Ohio's licensed pharmacists on what the effect of this HHS. They basically amended the Public Readiness and Emergency Preparedness Act for medical countermeasures against COVID-19. The amendment seeks to take steps to combat a decrease in the rate of childhood immunizations as a result of people going to the doctor less. There's been a noted decrease in the rate of childhood immunizations. So this is another communication that pharmacy board has shared with us. So to circle back to the rule, as I mentioned before, the statute requires a consult by the pharmacy board with us regarding a rule change in this subject matter. So basically the only action item on this is if you would have any questions or comments, these are things that we would convey directly to the pharmacy board to address with them. So I'd like to, at this point, give the opportunity for that. If no one has questions, then that's all I have.
Nate, just to clarify, unless there's a physician-established protocol and the physician determines what things fall in the scope of this doesn't happen, right?
Yes, the overarching is a physician-established protocol. That's correct. But this legislation allows, if this is included in the physician-established protocol, it allows the COVID-19 vaccination to be included within that protocol.
Right, but if the physician in question doesn't allow it, it doesn't happen. It's driven by the physician's decision, not the pharmacist, right? Pursuant to the protocol which the physician establishes.
Right. My understanding is that physician will establish a protocol with a pharmacy, and that protocol lays out some of the safety measures that what the pharmacist can do related to immunizations. And you're correct. If that protocol that pharmacy is working under doesn't include this, then yes, they would not be able to do it.
Okay, thanks.
Jonathan, I'm not a doctor, obviously, so forgive my ignorance here. Is what you're saying is that it becomes a contractual relationship between a doctor and a pharmacist or a pharmacy, and thus every doctor may have different protocols? Is that what you're saying?
I think this 4729.41 lays out what a protocol with a pharmacist should include. So okay. There are
so there are guardrails around it, and there are
guardrails around it. Right. It cannot just the protocols are not differing widely.
So there's a template,
I think
statutory template with some variations depending upon a doctor's desire, a protocol relationship, or the contractual relationship between the doctor and the. Okay, thank you. Sorry to bother.
So, yeah. So the guardrails around it are in Part C of the statute. The protocol has to specify a definitive set of treatment guidelines and the locations at which the vaccination can occur. There's discussion in the protocol regarding adverse reactions to immunizations. That's correct. That there are guardrails around it.
Thank you.
I have included it. Okay. Dr. Safford.
A question, if a patient doesn't have a doctor and comes to a pharmacy for these immunizations or vaccinations, how does that work?
I believe if you look at, this is listed under Part G of their rule. Sorry, I'm having a freeze up here on the computer.
Because it seems to be a relationship between the pharmacy or pharmacist and the physician. And if there's no relationship, then is the pharmacist free to do whatever they want to do? Then they're practicing medicine.
That's correct. Some of the immunizations under the authorizing statute have to occur by prescription, and others do not have to occur by prescription. But the pharmacist is still working under the physician-established protocol, which provides guidelines that the pharmacist must operate under.
But if there's no physician,
there's no
what guidelines. Yeah.
That's correct. For some of the vaccinations that are in here, if there is no physician who has delivered a prescription, then they would not be able to actually get the immunization from the pharmacist.
Okay.
If there's a prescription,
some of it is
no prescription required. I'm sorry, there's no prescription required, and I'm walking into my Kroger's pharmacy, and I have no doctor. Dr. Saffron question, I think, is really, I'm not a doctor, so it's a great question.
So I think, as with all great questions, it depends. And so I think some of it relates to the age requirements in the rules. So both the rule and the statute, honestly, are very complicated in the sense that there are different rules that apply to people who get vaccinations between the ages of 7 years old and 13 years old. That would require a prescription. People who are 13 years or older, there could be situations where it would, if the immunization was on the schedule, there's a certain schedule that the Advisory Committee on Immunization Practices, who advises CDC, puts out. If it's on that immunization schedule, then for people 13 years or older, that wouldn't be a prescription requirement. However, in addition, the rule adds, and this is detailed in the memo, and I am not trying to make this complicated. I think the way the rule and the statute are written, because it has so many different variants depending on which age group you fall in, it does become complicated. But the rule also adds a new, I believe it's the 6th issue I identified as differences, that for people aged, for adults basically age 18 and older, there's additional authorization that by prescription and according to protocol, adults aged 18 or older could get immunizations that are not on that CDC advisory committee list. So to answer Dr. Saffron and Ms. Montgomery's question, in a lot of cases, yes, there would be required a prescription. In some cases, no. It's a general physician established protocol that the pharmacist is working under. So that was probably as clear as mud, but the rule is in some ways there's a lot of detail to it, and it depends on the age of the person.
So Nate, it's kind of like when you go in for a flu vaccine, right? To the pharmacy, you don't necessarily have a physician. You go in, they administer it pursuant to the protocol, correct? That's what you're talking about.
Correct.
Okay.
The flu vaccination is a perfect example of they would be administering according to the protocol, not by a prescription.
Okay. And secondly, the rules are really an outgrowth of the statute, right? That requires or permits this, right?
The statute is authorizing the rules, and the rules reciprocally refer back to the requirements of the statute.
Okay. So whether we like the rules or not, the statute permits it. So it's really a matter of working to get the rules in alignment with the statute, right?
I think that the rules, particularly related to protocols and immunizations, the medical board has the power to consult and to, the statute provides the statute provides very general requirements. The medical board could ask for more specifics or have questions about things that the pharmacy board has made in the rule that have generally been authorized, but as everyone knows, the devil's in the details. So,
right. So I
would also note that the pharmacy board is simultaneously trying to get a statute passed regarding a COVID vaccination.
Okay, that was my question. So the COVID and the other vaccines in question are not permissible or not addressed in the statute? That's what I'm unclear about.
So I was able to have a conversation with Cameron McNamee, and the way it was explained to me is that when the COVID vaccination, and admittedly, this is a tricky issue because, as you're all aware of, presently there is not an approved COVID vaccination. So we're talking about something that will be coming in the future. But as it was explained to me, when FDA approves the COVID vaccination, it will be shortly thereafter, CDC, that advisory committee on immunizations, will add that to the list. But there will be a lag time between it being approved by FDA and then the advisory committee on immunizations that advises CDC meeting. So I will say the authorizing statute authorizes a pharmacist to immunize based off of the schedules that are approved by that advisory committee to CDC. So it's not outside of the authorizing statute. There's just a lag time. So I think the intent of this is to, because this is a pandemic, the intent of this is to
fast-track it,
create as few barriers as possible for people to get the COVID vaccination. So the idea is you wouldn't be waiting for that CDC advisory committee to meet and put it on the schedule and then publish the rule or publish the schedule. You would be, so there's a little bit of leeway. And I think that could be part of why they're also seeking authorization by statute as well.
Got it. All right. I understand. Given the urgency of getting the vaccinations available, they want to.
Right. Yeah, I would assume you could see a several month gap between when FDA approves it and when the committee meets and puts it on their schedule. When the committee meets and puts it on their schedule, that the statute 4729.41 authorizes a pharmacist to do it. But until then, you're in a little bit of limbo.
Thanks.
Sure.
Any other comments or questions? Thank you. Okay, we'll move on to the last item on the agenda, which is the MAC letter.
Great. Thanks, Dr. Stein. We received this letter last week from the Medical Association Coalition, also known as the MAC. And it's the full letter has been included in your packet for review. There are 3 different requests within the letter, and what we'd really like to do is, obviously, if anybody has discussion on those 3 points, I can walk you through those today. I'm happy to take some feedback today, But essentially, our request is that if the board is interested, or if policy committee is interested, staff would like to research each of these items further. They're pretty weighty topics. I think they're timely. I think they are, I thought it was a well thought out letter, and we appreciate that letter from our stakeholders. The three issues that have been identified are relative to the questions that we ask on our application about mental and physical conditions and impairments. The second issue is about exploring what we disclose publicly as part of our disciplinary process for illness or diagnosis. Excuse me. And then the third item that was raised was the possibility of what I would call outsourcing our confidential monitoring program, much like we do the One Bite program for first-time impairment issues. So again, all three very robust topics, I think, that really merit additional research if the policy committee is interested in us going forward with those three to bring back more information in the future.
So I don't understand what you're asking us to approve. That is that you will research on these three topics and then bring back information to us, but then what would we do with that information?
I think then at that point we would bring back research and recommendations. So let me clarify. We would bring research and recommendations to you. So that would, to guide the board's discussion. If I guess the real question is if any of these issues are non-starters for the board, these are significant time investments for staff. And we really don't want to go down a road of bringing something back to you with research and recommendation if it's something that's not of interest. I looking at all three of these, again, I think they're very timely requested, and I think that they merit additional research. But time is a precious resource amongst the state medical board staff.
Yeah. Okay. Dr. Bechtel, I think, has hand up first, then Dr. Schottenstein.
Oh, sure.
Stephanie, I definitely agree. I think it's important to do some more research and come up with some ideas. These are, significant recommendations. I do know that the medical community is really concerned about physician well-being. When I was president of the Columbus Medical Association, there was really a lot of concern that physicians with depression and other issues would not seek medical help because they were afraid that they would have to report that on their licensure, and that information could also be made public. And I do think it's important to intervene early on before a physician goes untreated and then ends up making a lot of mistakes that can harm patients and other things. So I think we really need to listen to them. And the other possibility would be, after your research and recommendations, a possibility of maybe inviting some of these members to participate in one of our policy committee meetings, so we could have them express their concerns and better understand where they're coming from.
Yes,
Hi.
Dr.
Thanks very kindly. So I also very much appreciate the MAC bringing this to our attention. I think it's timely, and I would be grateful for that staff research. With regard to revising the initial and renewal application questions to align with a current condition or impairment, the MAC group referenced the 2018 FSMB policy on wellness and burnout. There is a statement in that report, and it goes as follows, and I quote, "Applications must not seek information about impairment that may have occurred in the distant past, and state medical boards should limit the time window for such historical questions to 2 years or less, though a focus on the presence or absence of current impairment is preferred." Close quote. And so if you scroll down past the memo, you'll see some of the application questions that we have that really do not align with that policy. And so I think that our application questions really should attempt to obtain the most minimal amount of health information from a licensee, which still allows for a maximum amount of public protection. If there's something we don't need to know to achieve that goal, I don't really want to know it. And I don't really think we have any business knowing it. So I think every application question needs to be justifiable from a public protection standpoint. And if our consensus is that we need all these questions in the form they're in to do our jobs, then so be it. But if we can get the information we need in a more circumscribed way and achieve the same result, then I think that's the right thing to do. So I'd certainly be glad for that staff input to see if, there's a sense that we can move on that. As to the second point that they brought up about limiting the personal health information of licensees related to illness or diagnosis, I just gave a talk to the Mount Carmel residents about the non-disciplinary track. And one of the residents spoke up and said, when we fill out our application forms, those are public documents, right? So in other words, even just to apply, you potentially are revealing a lot of very private information about yourself. And, I think that again is a compelling point. So just wanted to sort of make those points. I thank you for your time.
Yes, I think that's great feedback, Stephanie. So, I look forward to hearing the recommendations and the information. I think it's clear that staff do want to dig a little deeper with research and recommendations.
Great.
And I think brainstorming about the recommendations are going to be a key important part to what Dr. Schottenstein was mentioning. I mean, is this important or actionable information for us to know? And is it stuff that we really, it's appropriate for us to get involved in, is good for you to vet out for us?
Absolutely. Great. Thank you all so much.
Great. That concludes the policy committee. Is there a motion to adjourn? And second.
Second.
Yep. And all in favor say aye. Aye. Thank you, guys.
Thank you.
Thank you.